Everyone who has ever been to a gym knows that it's a matter of basic decency to use a towel. The next person doesn't want to touch your drying sweat. Gross. Everyone who has ever been to a gym also knows that when you join a gym, you have to sign a long, detailed contract. Nobody reads it. But in any case, the 19-year-old fitness freak signing you up has no permission to change the contract. If you want to join the gym, you sign the contract. Take it or leave it. That makes the contract a standard form consumer contract. In this case, the contract provided to members by the Trainstation gym in Brighton in Victoria included a whole range of terms which really were unfair, heavily in favour of the gym to the disadvantage of the member. The Australian Consumer Law says that unfair terms in standard form consumer contracts are not enforceable. However, it also says that unfair terms can be enforced against the consumer if the unfair terms are reasonably necessary in order to protect the legitimate interests of the party who would be advantaged by the term. One of the terms disputed in this case was a term that allowed the club to set up rules and regulations for the operation of the club. Members signing up agreed to abide by those rules, and they were also agreeing to abide by any changes to the rules which the gym could make anytime they wanted. On the face of it, this sounds unfair. However, the gym argued that this was necessary in order to keep the gym safe and hygienic. VCAT agreed. The respondent argued that the rules and regulations were the means of controlling offensive and dangerous behaviour by members, and the power to terminate membership was required as the only way to ensure the safety and comfort of members is assured. For instance, the respondent suggested that patrons who did not use a towel and therefore left equipment covered with perspiration were a significant nuisance to other members, and a strong sanction was required to discourage such behaviour. It is not my view that such a term is unfair. This case gives us an example where a consumer contract may contain a clause which is unfair on its face, but which is necessary to protect a party's legitimate interests.